Welcome everyone to this Privacy Rules Privacy Espresso. Today we are going to speak about the EDPB position on the new EU-US privacy framework, and we're going to do that with Magdalena Gadnova, coming from Timelex, the law firm based in Belgium, Brussels to be specific, member of Privacy Rules, of course. So first of all, Magdalena, thanks a lot for being with us today.
Hi, Alessandro. Hi, everyone. Good to see you again. Thanks for having me.
As you perfectly say again, because this is the second time that we are touching upon this topic. So why don't you provide us with a brief overview on what we are talking about today?
Okay, so to jog everyone's memory, last year the European Commission issued its draft adequacy decision, which was based on the EU-US data privacy framework to replace the US Privacy Shield, which was invalidated in 2020 by the Court of Justice of the European Union. The key component of the new data privacy framework are the EU-US data privacy framework, 7 core principles and I believe 16 supplemental principles. And the Commission requested the European Data Protection Board to issue its opinion on the draft adequacy decision. And the EDPB released its non-binding decision on this new framework. Taking into consideration the adequacy referential, the list of key elements, which was adopted by the EDPB, that a third country's national legal framework should contain for it to be considered ensuring adequate level of protection, essentially equivalent to that of the European Union. So based on this, the EDPB assessed the commercial aspects of the framework and the provisions relating to the access to and use of data transferred from the EU to the United States by the US authorities. And with respect to those commercial aspects, the EDP noted that those remain largely unchanged. But that's not necessarily a concern because the issue with the Privacy Shield was that the US authorities were able to access the data transferred to the United States under the US law rather than the principles of the Privacy Shield themselves.
That's perfect, and thanks a lot for this background of what we're talking about. Speaking about the European Data Protection Board, we saw that it took, position in favor or against some parts of the draft decision. So what did the EDPB like?
Yeah, so to start off with the things that the EDPB liked. Well, the EDPB definitely liked the implementation of the requirement of necessity and proportionality for the gathering of data by the US intelligence. However, the effects of this amendment should be assessed in practice by the European Commission, and that would involve the review of internal policies and procedures implementing the executive orders safeguards at the agency level. Secondly, the EDPB liked the adoption of a redress mechanism for EU individuals. It found it to be significantly improved. In the opinion of the EDPB, the new redress mechanism introduces more effective powers to remedy violations, including additional safeguards both for data subjects and for the independence of the Data Protection Review Board. With respect to safeguards for data subjects, the new framework introduces the so-called special advocates to advocate in favor of the claimant's interest. And with respect to the independence of the Data Protection Review Court, the EDPB noted that the safeguards that were implemented within the new framework do not give reason to doubt the Data Protection Review Court's independence, something that was, brought up by Max Schrems previously when we talked back in December. But here the EDPB stated that there are no reasons to doubt and question the independence of this Data Protection Review Court. The EDPB also welcomed the list of specific purposes for which the collection of data can and cannot take place, though it did mention that the President of the United States can expand on this list of specific purposes without necessarily making those public for reasons of national security. So the Commission should take note of that. And it also welcomed the US authorities' commitment to prioritize enforcing the new framework. So these were the things that the EDPB certainly liked about the new framework, but it also flagged other issues and concerns.
Yeah, and speaking about it, I mean, I will leave the floor to you also to give us some insights on which. things they dislike.
Okay, so we talked about things that they liked and things about they didn't like.
Exactly.
There seem to be more of those.
Okay.
Maybe not that they disliked, but should be either clarified, reconsidered, or negotiated. First of all, the EDPB noted that the executive order of President Biden, which introduces those amendments to the framework, hasn't been fully implemented yet. It isn't fully reflected in the internal procedures of the U.S. law enforcement and intelligence agencies. And the EDPB noted that the Commission should make the adoption of its adequacy decision contingent upon the executive order being implemented into those internal procedures of the U.S. surveillance agencies. It also recommended the Commission to assess these updated policies and procedures and share this assessment with the EDPB. Secondly, the EDPB disapproved the scope of exemptions to the adherence to the principles. So currently, the principles, the data privacy framework principles, provide that certifying organizations can diverge from those principles in certain situations. These exemptions should be clarified because they're unclear, and the European Commission should also be informed and actively monitor adoption of any statutes or any other governmental regulations that would affect the adherence to the principles. Moreover, the EDPB noted that framework, the principles, the structure of the annexes make it very difficult to find the principles and to refer to them, which makes it very difficult for the stakeholders to get a good grasp of what the framework looks like. Also, it noted that the document uses some terms that are undefined, which leads to legal uncertainty, and the terminology that's being used is not used consistently throughout the document. So that was also brought to the attention of the Commission. Moreover, the EDPB disliked the broad exemption to certain fundamental data subject rights, like, for example, the right to access data. There's a broad exemption, which basically deprives the data subject of the right to access if that data came from public records or was already publicly available. So the EDPB noted that to reject the data subject request to access his or her data purely on the basis of the fact that that data was publicly available would deprive the data subject of the right to verify the accuracy of his data, and secondly, control the lawfulness of this data being made public. So that's something that the EDPB disapproved. It also noted that the right to object to the processing of data, which is envisaged in the framework, do not contain the modalities of this right. Hence, it is difficult for the data subjects to actually exercise that right if they don't know under what conditions this right could be exercised. Other things that were very important were, for example, lack of sufficient safeguards for the bulk collection of data. The executive order does not provide for a requirement of prior authorization by an independent authority, as well as lack of systematic review by an independent court or body. Moreover, although it did approve the adoption of the redress mechanism, it was really concerned about the practical functioning of the mechanism. Under the framework, after the review of the complainant's application is completed, the Data Protection Review Court must not reveal whether or not the complainant was in fact subject to surveillance activities. And in the view of the EDPB, this is simply not sufficient. Plus, this response is non-appealable. So the EDPB called on the European Commission to closely monitor the functioning of the redress system. And lastly, but not least, the lack of rules on automated decision-making, including profiling. The principles do not address issue of decisions affecting data subjects based solely on automated processing of personal data, and such rules are necessary to safeguard the rights of data subjects, and they should include the individual's right to at least know the logic behind, challenge the decision, and the obtain human intervention when the decision significantly affects that data subject. So the overall opinion is positive. However, the EDPB expects the Commission to address those concerns that I just discussed and to provide additional explanations to solidify the grounds for the adequacy decision.
Magdalena, thanks a lot for this overview on this very interesting topic and your time. It was a pleasure speaking with you. And of course, I would like also to thank our listeners for being with us also today. So I invite you and all of them to follow us with our next Privacy Espressos.
Thank you, Alessandro.